Thank you so much, Dr. Joseph Coniglio, for accepting to have this conversation with the African Competition and Consumer Protection Center, where we hold conversations with different speakers from Africa, Europe, Asia, America, Latin America, to discuss important questions pertaining competition law enforcement and provide a platform whereby we can discuss issues and share ideas that would lead to more competitive markets. So today we are having Dr. Joseph Coniglio. I hope I'm pronouncing it well.
That's fine, thank you.
Yeah, from the Information Technology and Innovation Foundation, briefly called ITIF. And Joseph is the director on Antitrust and Innovation Policy, and his work encompasses all areas pertaining competition policy, but in a particular with a focus on digital platforms, monopolization policy, and also dynamic competition. And he has experience in the regulation of digital markets, and he has written insightful research articles on the way forward in regulating the biggest challenge that many countries and competition agencies in the world are trying to grapple with, the regulation of competition in digital markets. And therefore, today we are going to hear insights from him regarding how to regulate competition in digital markets and how other countries, especially in Africa, who are yet to adopt digital market competition regulations, can approach this issue. So thank you so much and welcome. And maybe as an introduction, you could tell us what ITIF does. What do you mean by Schumpeterian review? How does it differ from other intellectual thinking regarding the regulation of competition in digital markets? Thank you.
Sure. Thank you, Bella, and also thank you to AFCCP for hosting me. It's a pleasure to be here on behalf of ITIF. And just to start, ITIF is a independent, nonpartisan think tank based in Washington, D.C., focused on promoting pro-innovation policies in the American economy, but also throughout the world. And I focus specifically on antitrust policies that are focused on driving innovation, and specifically informed by the work, as you noted, of the economist of Joseph Schumpeter, who talked about competition as a process of creative destruction and really seeing innovation as opposed to, let's say, price competition as the major driver of how competition and capitalism ultimately works. And, for Schumpeter, and we can certainly discuss this more, in contrast to the sort of Adam Smith model, where competition is defined in terms of many, many small firms in the market, many buyers, many sellers. Schumpeter saw competition and this innovation as driven in many cases, if by large firms, by scale, concentration, who had both the ability and the incentive to make the investments and engage in the risk-taking that ultimately creates and spurs those big innovations that, as we know, are the largest drivers of economic growth and overall consumer welfare. So at ITIF, we try and put forward antitrust policies that are conducive to the fostering of innovation, which I agree is really, really very important now, but also in particular as we are at sort of an inflection point in global competition policy, when I think sort of the old status quo is increasingly being challenged and folks are looking for new ideas about how to frame competition law and competition policy in digital markets in particular. So we think Schumpeter has a really great framework to start thinking about some of those issues.
Okay, thank you so much for that introduction. And I think anyone listening to this will really understand why innovation is at the core of the work that you're doing. Maybe you could also tell us more about the US approach. We know a lot about the EU as the forerunner in adopting a digital market regulation. So how is the US approaching this issue?
Sure. So I think the US, the history of antitrust and regulation over the past 40, 50 years really does provide a very interesting story that not just that we learn from, but I think other jurisdictions can learn from as well. So 1950s, 60s, really beginning with the New Deal, 30s, America had a very highly regulated economy across a lot of different industries. So railroads, transportation, telecommunications, highly regulated by the state. And ultimately, what people realized was this sort of heavy regulation was harming American innovation and competitiveness. There are lots of stories that one can say here. But I like to focus on the media industry as I think one really good example, where you had a lot of regulation that ultimately was basically protecting the broadcast incumbent companies and stifling competition ultimately from cable and other sources. So eventually, the United States, for a lot of reasons, for economic reasons, but also geopolitical reasons, seeing increased competition from Europe and Japan in particular, started to move away from regulation and move towards a more deregulatory model focused on consumer welfare, especially in antitrust, but also more broadly. And the results of this shift towards deregulation, which I would note was bipartisan. A lot of folks say that, like to say it was just a Reagan thing, but no, it actually started in the Carter administration in particular, with sort of bipartisan understanding that regulation had sort of gotten out of hand, and antitrust policy as well. So again, the results vary by industry, but in general, deregulation was seen as improving economic growth, improving innovation, making the American economy more dynamic, and also making us more competitive abroad. And I think, certainly from an innovation perspective, there are certainly good reasons why I think America led the digital revolution and some of these high-tech revolutions, because they had a regulatory and an antitrust environment that was conducive to that Schumpeterian competition, that innovation competition, which is really at the heart of creating a dynamic, high-tech digital economy. So, and I think today it's true that there's a big debate right now in American antitrust about sort of what the future is going to be. But I would note, when it comes to digital regulation, as opposed to sort of antitrust policy, sort of law enforcement, I think that historical model is still very, very much in the minds of a lot of folks, and the lessons from history. So I think it's very unlikely that the United States is going to deviate from the model that's been very successful at creating a dynamic, innovative economy, especially when we're facing a lot of competition now from China, and we need to make sure the United States stays technologically on top. So I think digital regulation is highly unlikely. There have been proposals in Congress for a while now for DMA-like legislation, the American Innovation Online Choice Act, for example, and these have basically stalled. And I think now, especially with the new administration coming in, Republican administration, I think it's very unlikely that we see any sort of big digital regulation in the United States in the near term. And I think that's good policy, and again, informed by the prior experience of the United States in dealing with regulation.
Okay, so you presented the case of the US and why promoting innovation should be at the core of the digital market regulation. So what is it that Africa can learn from this approach, or developing countries in general?
Sure. So I would step back and say, when it comes to thinking about innovation, I think the U.S. model is certainly something Africa can look at. But ultimately, there are sort of general legal and economic principles that we need to think about when we're thinking about when digital regulation makes sense. And the first is whether or not there is market failure in digital markets in a way that sort of standard law enforcement tools, as opposed to ex-ante regulation, can't solve, right? That's sort of the first major question that African policymakers, or any policymaker, should ask when they're doing ex-ante regulation. And the second problem is this, or second question is ex-ante regulation going to actually improve the status quo, right? Even if you have market failure, or is it going to make things worse? And I think what we're seeing around the world with a lot of the spread of these DMA-like statutes or regulatory regimes is it's not clear that these two conditions are satisfied. Namely, that you have real persistent market failures that regular ex post antitrust enforcement can't solve. And then second, that you're going to actually make the status quo better through ex-ante regulation rather than worse. So I'm happy to drill down on those points if it would be helpful.
Yeah.
So in general, when you're thinking about maybe more developing companies, countries, emerging economies, many of these economies very strong, very healthy, but their digital markets are still emerging, right? So when you have emerging digital markets, they're nascent. It's not really the type of industry or characteristics that you would expect to find market failure, right? Market failure is when you've had high prices, diminished innovation, reduced output for a very long time, very durable. It's not the sort of thing that really transpires in nascent digital markets, right? The markets are still growing, they're evolving, right? To say that there's market failure is usually premature, and it's something we see a lot in more emerging economies. So that's point number one. Point number two is also when you talk about smaller, more emerging economies, many of their regulatory regimes, right, are still developing competition policy regimes. They may not have done, let's say, ex post investigations, of large technology companies that they may be concerned about. So there's no reason to think necessarily that regular antitrust law can't do the job, right, to solve these problems, right? Using your existing tools first. So, if a competition regime is relatively young and it hasn't done any, serious ex post antitrust investigations of large technology companies, right, it's premature to jump to ex ante regulations right off the bat, because again, you don't know whether or not regular antitrust enforcement, such as the kind that they're doing in the United States, for better or for worse, I think there's a lot of problems with a lot of the cases that are going on in the United States, but at least still, doing some good law enforcement before jumping to regulation, I think it's very important. But then second, even if you have market failure, right, and you're maybe concerned about your law enforcement tools, regular antitrust enforcement to deal with that market failure. Again, this is true for every economy, but I think also very much for emerging developing economies is regulation can ultimately impose costs on entrants and stifle competition and stifle innovation, right? Regulators often lack the knowledge necessary to sort of decide the rules of the road that are going to be most efficient ex ante. And that's a problem that's really particularly acute when you're dealing with fast moving digital markets, right? Regulators really don't necessarily have the knowledge in advance to know what are going to be the right parameters to maximize innovation and competition. And that's a common problem with regulation that we've seen in the United States, but throughout. And also, what I would say is another problem of regulation, and it's a general problem, but I think also very much true in emerging developing economies, is regulatory capture. So this idea that ultimately the regulation ends up benefiting the incumbents, right, and not the entrants and the sort of competition you want to develop, and it stifles dynamism, right? And this is not a problem that's at all limited to maybe countries that are a little bit less used to a rule of law type tradition, but even the United States. I mean, the Robinson-Patman Act is a great example. Even in the U.S., where we pride ourselves on the rule of law and fairness, and the Robinson-Patman Act was clearly used to benefit incumbents, smaller grocers, to prevent competition that benefited consumers, namely large chain stores like the A&P. So those two problems, shilling innovation, not having enough knowledge to really know what good regulation should look like, and then also regulatory capture, are very real generally when it comes to the issues that can result from ex ante innovation, but I think are especially acute both in digital markets, right, where you have these fast moving environments that are constantly changing. It's hard for regulators to keep up. And again, the rents are very high in many cases for the winners in these digital markets, which only increases the incentives for regulatory capture, right? Because if you win, you're going to win big in many cases. And then again, yes, the regulatory capture point, where again that's something that it not necessarily just at all. It's a general problem with regulation, but something again very acute to digital markets and also developing and emerging economies.
Okay, so you raised these issues, and I just kept asking myself. So when we look at the US market, and okay, let me talk about African market, whereby most of the businesses are small, medium-sized enterprises, and the argument out there is that because of the characteristics of the digital market system, whereby we have the network effects, we also have the big tech companies which have already accumulated data, and data is an important infrastructure for the SMEs to be able to enter and participate into this market. So in this case, as it's argued, is that the African SMEs are not able to innovate because the big tech companies that already have monopoly in the African market, the Google, we can talk about other markets, maybe like Booking.com and so on. Amazon is not really a big company when it comes to Africa. So they have put in place barriers that really hinder innovation. And I'm just trying to understand how we can be able to address these issues that have been raised, and also to ensure that African SMEs are able to enter and also compete in this market, or even participate and expand in these specific markets.
Sure. So again, I think right off the get-go, it's worth noting that big is definitely not bad in digital markets. And I think there's this concern that we've seen in many jurisdictions, in Africa, but throughout, that any market that has large firms with network effects is something we need to start to regulate. And again, that's not market failure, right? Market failure is not the same thing as having a big firm in your market that has network effects, right? Market failure is when you have maybe a big firm in your market, but you have persistent declining output, declining innovation, higher prices, in a way that lasts, over a long period of time, that suggests that there isn't dynamism. And what I would say is Africa's, you can't generalize, of course, but in many cases, the jurisdictions we look at in Africa and others, Kenya, I would say, is one we've looked at closely, where you have dynamic digital markets. You have markets that are still developing, right? It's not at all the case that we've sort of seen this market failure it persist or even exist at all, in a way that would justify regulation. So, for example, in our comments to Kenya, we noted that the country's e-commerce sector was booming with I think something like 40% of businesses engaged in e-commerce. I mean, those are good numbers, right? Again, law enforcement tools, when you look at Kenya, right? Before we jump to digital regulation, we should make sure that we're using our ex-post tools first to see whether or not they can resolve competition issues that may exist, right? So suppose there is an issue with a large American company that's acting anti-competitively. Let's use our ex-post tools first to try and resolve that before we jump to a large, heavy-handed regulatory regime. And I don't think there's any reason to think that, let's say in Kenya's case, for example, that its ex-post tools are insufficient, right, to deal with those problems, such that we need regulation. So that's sort of the first point I would make. The second point I would make, again, is that network effects and size in digital markets are not necessarily a bad thing, right? Sometimes that is just how the market works. And, network effects exist in a way that sometimes creates value for consumers, right? Because the more people that, let's say, use a platform, the more valuable it becomes to consumers, right? So those network effects can have pro-consumer effects. And then also, when you look at the Schumpeterian angle, again, scale and size and concentration are not necessarily against innovation, right? They actually sometimes foster innovation. At ITIF, we believe, as the empirical literature, I think, strongly suggests, that innovation often takes the form of an inverted U, where if you have too much deconcentration, you don't maximize innovation. If you have a monopoly, you don't maximize innovation. But if you have a structure where, there's a number of firms that have a lot of scale, but also are competing dynamically with each other, you maximize innovation. And at least in the United States, that's very much what we see with a lot of these large technology companies, whether they're Google, Apple, Amazon, Microsoft, Meta, et cetera. They all have scale, but they're all competing with each other for the next generation technologies, like, let's say, in artificial intelligence. So, network effects and size are not necessarily at all anti-consumer or anti-innovation. In fact, quite the opposite. But your question, I think, goes to another point that we also see, which is this idea of digital regulation in the context of broader geopolitical concerns, right? So, and political concerns. So it's not just about maximizing consumer welfare and innovation. It's, how do we, ensure that our country has a strong, flourishing digital industry, and that our markets aren't necessarily, let's say, I'm saying it simplistically here, but, it's only American firms, right? We want more of our country's firms to be dominant, right? So that's a different question from just innovation and maximizing consumer welfare. And it's certainly one that we hear, not just in African jurisdictions, but throughout the world. And what I would say here is that, first of all, if you have a policy that maximizes or is not focused on maximizing innovation and consumer welfare, that's going to be bad for your country's competitiveness, right? Your country is going to be less competitive, the less innovative, the less dynamic its markets are. So that economic power ultimately is a big part of broader geopolitical power. And if you want a flourishing, dynamic economy, that's ultimately going to help you in the long run geopolitically as well. So that's one point I would make. I mean, maximizing innovation is in itself going to be good for a country's national interest overall. And the other thing I would note is that sometimes this sort of it's a way of regulatory capture almost, right? Using regulation to benefit certain companies over, let's say, foreign companies. That can have a lot of negative effects on countries, especially smaller countries who are trying to, let's say, benefit their own companies at the expense of, let's say, large American companies, right? That can have a lot of blowback, right, by reducing investment, right, from large companies into these economies, and also creating trade and other tensions, right? It's with respect to South Korea, for example, which is considering digital regulation of various kinds, some ex post, some ex ante. There was a bill actually passed or proposed by a congressperson suggesting that this regulation might unfairly target American firms, and that could have negative consequences. So it's not at all the case that pursuing ex ante regulation is necessarily going to be the best way to support national champions, right? It can actually end up having the opposite effect. And I think that's important for policymakers to keep in mind, especially if they're part of smaller companies countries that may depend a lot on U.S. investment, right, in their economies. Introducing regulation that is really focused on targeting, let's say, American companies, could ultimately end up doing a lot more harm than good.
Okay, thank you so much on this. We'll come back to these issues as we discuss the goals of the digital market regulation. But in most of your advisories on emerging digital market regulations or amendment to competition laws in order to provide power to competition authorities to be able to regulate issues within digital markets, you've argued that the anti-competitive conduct should not be per se prohibited. Maybe you could say something about that as well.
Sure. So again, this is true whether in an ex ante regime or ex post regime, right? It's a separate question.
Yeah.
Have a per se rule in an ex post regime. You can also have per se rules in an ex ante regime. So it's a separate question from whether you do ex ante or ex post regulation, but it is very important. And in many cases, not all cases, some jurisdictions have decided not to have per se regimes, right? Like the UK's
Like which one?
Like the UK's DMCC, for example, has the ability for firms to present pro-competitive justifications, for example. But many of them do follow the DMA's lead and have these per se rules. And again, it is a high level, whether it's dealing in regulation or ex post enforcement. Per se rules are supposed to be used for conduct that is almost always going to be anti-competitive, right? And the benefits of looking at the specific instance of that conduct are really null, because we know and have very high reason to think that when this conduct happens, it's going to be anti-competitive. And any error costs, right, of let's say chilling pro-competitive behavior are really non-existent, and we just want a more administrable regime because we know the conduct is going to be anti-competitive. That's when you use a per se rule. And again, in the United States, this is for cartel agreements, right? We have a very good reason to think that cartel agreements among oligopolistic firms are going to be anti-competitive. We don't need to evaluate those effects. They're per se unlawful. Horizontal collusive agreements, right? Sort of the standard case. However, there's a lot of benefit conduct that is not like that. In fact, most business conduct is not like that, and ultimately has pro-competitive benefits, right? Could be anti-competitive, but could also have a lot of pro-competitive benefits. And the error costs, right, from a per se rule could be very high, right, in the form of chilling pro-competitive behavior in a way that sort of outweighs any administrative benefits you might get from having a simpler, just conduct-focused rule, right? So it's this trade-off between minimizing error costs and minimizing administrative costs that you want to think about when you're deciding which rule you want to apply. For conduct that's really bad, right? The error costs, you know it's going to be bad. Error costs are low. You want to maybe weigh towards administrability. But for conduct that could be good or bad, right? You don't want to chill false positives. You want to do a rule that looks at anti-competitive effects, for example, and allows firms to make pro-competitive justifications. That's sort of the high-level framework. And when we think about the type of behavior, and again, the regimes vary, but in general, the type of behavior that the DMA and other ex-ante regimes or proposed regimes are looking at, it's very much the sort of conduct that's in the latter category, right? So, conduct like self-preferencing, bundling, tying, refusals to deal, right? This is all behavior that very often has pro-competitive justifications, right? And is not resulting in harm to consumers, right? And for that reason, per se rules are really inappropriate to evaluate that type of behavior. And in fact, we're already seeing this in the DMA, for example, with how certain restrictions on Google's ability to, let's say, feature its Maps products, right, are ultimately not just harming consumers, right, because it's making it harder for them to engage in more searches and clicks to get the information they want, but it's actually harming a lot of the smaller businesses, restaurants and hotels, right, because traffic is being diverted away from their website and to intermediaries, right? So it's this idea of how this type of behavior, often very pro-consumer, and how regulation can have unintended consequences that are anti-consumer, right? False positives that we want to be really aware of when we're thinking about this type of behavior. So again, I would say in general, the type of conduct that these regimes are regulating is very much the sort of behavior that for which a per se rule really doesn't make any sense. And we need to be first having the government show any competitive effects or any competitive harm, and then allowing companies to present pro-competitive justifications for their behavior, sort of the rule of reason analysis in the United States. That's the way that this behavior should be evaluated, whether it's ex post or, if you decide to do an ex ante regime, for example.
Okay, thank you so much. I think our listeners will really gain more knowledge on this. So now we've talked about all these topics. Now let's go back to the big issue, the EU Digital Markets Act, which it has received a lot of criticism, and some people have also supported it as a legislation that will ensure that there's contestability, which simply means there will be lower barriers to entry in the market to enable a smaller business to be able to enter into the market. And also the issue relating to fairness, because it's argued that there's imbalance of power, especially in the context of developing countries, making the big digital companies impose unfair trading terms, and therefore hindering competition. And therefore, we've seen a number of countries like India, maybe Brazil, approaching the issue of digital market competition regulations by looking towards the DMA. And I'd like to know your opinion regarding the future of the DMA. I know you've mentioned why we should not copy paste it, but maybe you could also just expound on that. Because most of the African countries always look towards the EU when it comes to competition law and enforcement.
Sure. No, that's certainly a fair point. And again, I think it's true that in many cases, even the EU's competition model, right, even separate from regulation, has been very influential in informing the rise of competition regimes around the world. So there's no doubt there's a Brussels effect, and it's real, both in regulation and also ex post. But what I would say is, again, history is helpful here, and let's just focus on the competition side, because the EU didn't do regulation. The effects aren't looking good, but we don't exactly have a natural experiment to look at beyond the US model that I talked about before. But certainly the US and the EU took very different models of competition policy the last 40 years, right? And the DMA, I think, is a very much part of that broader approach to EU competition policy that you described. So this is about protecting effective competition, right? Making sure there actually are enough competitors in a market, maybe bringing in concerns like fairness, for example. And that's very different from, and in exclusionary conduct cases, for example, not necessarily requiring proof of anti-competitive effects and consumer harm in order to condemn behavior, right? That has been the EU's model for a very long time. They started to move away from it a little bit in the early 2000s when I think they realized that they were already falling well behind the United States in the digital revolution, but it was already, I think, a little bit too late. But that is kind of the point, is the EU and the US had very different approaches to evaluating unilateral conduct, broader competition policy the last 40 years. And I think it's very clear that the US model was much more conducive. I'm not saying it was the sole cause by any means, but it was much more conducive to spurring innovation and growth than the European model. And again, it's not the sole cause, right? But I think it's a big part of it. And the reason is simple. If you're talking about Schumpeterian competition, right, and that's really what ultimately drives a lot of innovation and scale. Well, if you have the European model where you want decentralized markets, right, effective competition, that is not conducive to Schumpeterian competition. That's sort of a big is bad type of understanding of competition. Whereas the US model focused on consumer welfare, not perfect, but much more likely to be conducive to innovation. And again, I think this is no longer, if it ever was an open secret, it's certainly not anymore. I mean, I think if you look at the Draghi report, for example, there is a real recognition in Europe, and I think it goes back even decades before, but certainly now, that Europe has basically missed the digital revolution, and it is way behind in its high-tech economy relative to the United States. And that lack has basically driven the productivity gap between the US and Europe that has emerged. And competition policy, and I think President Macron actually said this in a speech at the Sorbonne. It's the ordoliberal model of competition policy, this sort of decentralized approach, needs to be rethought, right? And may have been part of the reason why there was this lack of innovation in Europe relative to the United States that ultimately translated into this productivity gap. So to the extent to which the DMA, I think it really does double down on that ordoliberal model of competition policy, I don't think that's going to be good towards fostering innovation and competition in Europe. And I think there are some reasons, to think that I think even many in Europe themselves now are starting to recognize. So with respect to your second question, the DMA is sort of being the Brussels effect and countries following it. What I would point out is the DMA is certainly not a one-size-fits-all approach.
Yeah.
So not only, as I mentioned, there are many, the United States is very unlikely to do anything close to the DMA. And there are other jurisdictions that have adopted a similar approach, like Singapore and Taiwan, and frankly, many others, but specifically those that are considering it and have decided against it, right? That is certainly a path. There is a trend there. But even countries that, have decided to do something, right? So as you noted, many of it is amendments to ex post laws, right? They haven't necessarily decided to do ex ante, right? They've tried to modify their ex post. And it looks like even maybe Korea may go that way based on its new bill over there. But then even for those regimes that have done ex ante approaches and decided to do ex ante regulation or propose it or considering it, their legislation in many cases looks very different from the DMA, right? So it's not. So I'll give you an example. So some regimes, you mentioned Brazil, right? Brazil's rules are very different from the DMA, in particular with respect to the number of firms that are captured by the regulation, right? So the Brazilian law captures a lot of different companies, right? Not just U.S. companies, right? By any means. So again, it's kind of like the DMA. It has these per se rules and it has this code of conduct, but again, not at all like the DMA with respect to its focus on U.S. Companies, and then also, for example, on the general, like I said, code of conduct, the DMA puts these per se rules out for everybody, and they apply the same. Some countries have decided to do a different approach, like India in the UK, where they do codes of conduct on a company-specific basis, right? They're not just general rules for everybody.
Yeah.
So you see a lot of variation, even among the ex-ante regimes that are out there. And I think very few follow the DMA to a T with respect to, per se rules, generally applicable to all the companies that applies to, basically targeting, American firms, right? Those three characteristics are not at all shared by even the countries that are pursuing ex-ante regulation. And then again, there's a lot of countries that are just maybe thinking they're going to do their ex post. They're only going to modify ex post and not do ex ante. And then even those, like I say, like the United States, Singapore, Taiwan, that have actually really considered doing something, whether ex post or ex ante, at least at this time, have decided not to. So yes, the DMA's trend, but I think to the extent that countries in Africa or elsewhere see it as sort of a gold standard, right? And this is like the best approach. I don't think that's at all, or the consensus, let's say, I don't think that's at all clear. And I think as more and more evidence comes out about some of the negative effects that the DMA is having on European consumers and European businesses and innovation, that consensus, to the extent people think there's a consensus, is going to be even less compelling to countries that are considering their own type of ex-ante regulation.
Okay, thank you so much. So another question from the arguments I read out there is that the US cautious approach in adopting legislations like the American Innovation and Online Choice Act or the Open App Markets Act or Access Act is because the kind of companies we are trying to regulate are US tech companies, and therefore they not only have the economic power, but they also have the political power. And having technological development in itself is a political power, and regulating is also political power. So we're having the EU trying to use the DMA as a political instrument to enhance its digital sovereignty or protectionism, while the US is also trying to use less intervention in order to build its technological muscle for political outcomes. So my question is, do you think that these tech companies, let me not say big or US tech companies, because the South African Competition Commission has shown us that in some of its sectors, like in e-commerce, South African digital platforms are the ones leading in those specific platforms. So we are going to observe domestic platforms in other jurisdictions that are also big tech within their own jurisdiction. But do you think that these big tech companies have the political power to influence regulation?
Sure. So this is a point that we hear a lot in the United States associated with the neo-Brandeisian movement, and Lena Khan and the folks that were, I guess, very close to formally in charge. There's going to be a new crop of enforcers very soon. And basically their central argument is that antitrust, when it was focused on consumer welfare, missed the political importance of markets and antitrust, right? That's what, and the idea is that economic power is not just bad. I mean, they certainly believe it's bad for economic reasons, right? Big is bad on economic ground, but it's really bad because it harms democracy, because you have private political power, let's say, is translated, private economic power is translated to political power. And the idea is if you want a democracy, you need to have, in politics, you need to have an economic democracy, right? Decentralization in your economy, right? No big firm, or, fighting big firms, if you want to have a decentralized political system, right? A democracy. That's really the core of their argument. But the truth is, there are a lot of problems with that argument. And I think it's taken for granted by many folks. But actually, when you look at it, it's not entirely clear that it actually holds any water, even if you grant their view that antitrust should be about politics in some way, which I think it shouldn't. And there are reasons why that's a problem in and of itself. So first, when it comes to, let's say, a firm having a monopoly or market power, that doesn't necessarily translate to political power at all, right? So you can have a firm that, let's say, has a great pharmaceutical product, right? It's got a monopoly, right? It may have absolutely no political power by virtue of having that one drug that's great, right? There could be a ton of other incumbents that really have, that have the system under much more favorable to them, right? So just because you have a monopoly in a product or have some kind of market power doesn't all mean that you have political power. And then conversely, there are a lot of firms that don't necessarily have a lot of market power in the United States, certain financial firms, for example. Generally their industries are very competitive, whether you're thinking about investment banking or asset management, but they can still have a lot of political power ultimately, right? Just because they, even though they don't have a monopoly. So I think the link between having monopoly power, economic power, and sort of undermining democracy at a formal level, it doesn't really hold water. That's point number one. Point number two is one of the best ways to break up concentrated political power, based on sort of, let's say, established economic positions, is through Schumpeterian competition, right? I mean, when you have new industries being created and new firms that are coming to disrupt the status quo, that does in a way create more of a democratic system, right? Because the old incumbents are now challenged by these new powerful firms, right? So, if you looked at, let's say, the leading firms in the stock exchange, U.S. stock exchange, from, let's say, 1980 to 2008, right? You have a lot of banks, you'd have a lot of oil companies, things like that. But today, all the largest companies are obviously these tech companies, right? So there's a transfer of political power in a way that has happened as a result of Schumpeterian competition, right? A disruption of the status quo, right? And that's actually limited the incumbency advantages that a lot of other more, let's say, long-established firms have had. So that actually, I think sort of is a different way of looking at the political question, right? But more broadly, what I would say is, at least in the United States, the neo-Brandeisians idea that even assuming that there is this ability for large firms to control the political system, this was a big debate for a while, right? This is something the founding fathers in the United States thought a lot about, right? They called it the problem of faction, right? And private interests using democracy to their benefit. And what they ultimately came down to say was, well, that's true, that can happen. And because of the problem of faction, the best way to deal with that is not to empower government, right? Because if there's really a problem of regulatory capture and faction, if you make the government bigger, it's just going to exacerbate that, right? The best thing to do is have limited government, because that actually itself is the way to mitigate the problem of faction. So it's this idea of, if you have this tension between capitalism and democracy, the neo-Brandeisians sort of want to attack capitalism and make firms less powerful, whereas the solution proposed by generally in the American founding was to limit government, deconcentrate government as a response to that problem. So, I think that's ultimately the better approach, and the one that's sort of more consistent with the broader American tradition of limited government and fostering the innovation and creative destruction that, as I noted, in the long run, is ultimately what drives the dynamic economic and also political system, frankly.
Okay, thank you so much. Because you've mentioned the issue of remedies. So before we discuss the issue of appropriate remedies, on the question relating to innovation, it seems like at ATF, you're pushing more for the goal of innovation, which I would think it wouldn't be the main goal of digital market. Let's not say regulation or investment in digital market. And I'd like to know if, in your opinion, you think that any other goals that would complement the goal of innovation.
Sure. I mean, I certainly think that there are other goals that a society needs to take into account if it wants to be a healthy, flourishing society. That's a broader question of sort of what the good is, and I'm not really prepared to opine on that. We probably need another hour to have a discussion on that. But what I would say, certainly innovation is generally a very good thing, and it can actually foster a lot of these other goals that people think are important, like helping the poor, right? Having a new innovation that makes things cheaper, improves economic opportunity. All of those, many of these other goals that folks like to talk about and are very important, innovation can help foster. So that's one thing I would say is I don't necessarily think there are going to be any big trade-offs. Maybe you can think of a goal that's really important, then innovation hurts, right? But I think in general, innovation is a good thing and actually helps support a lot of other goals that we feel are important. So that's, I think, point number one. Point number two is, innovation in itself, I don't think should be minimized. It is the largest driver of economic growth in the long run, right? And that's a really important thing. And as I pointed out, if you want a dynamic political system, right, where, innovation and creative destruction can also help that, right? I mean, capitalism disrupted the old feudal order for a reason, right? And democracy, I mean, those two things work together. And I think that's still in many cases very true. So I would say, yes, is it possible there are trade-offs between other things that we value in innovation? Sure, right? But in general, I think innovation is a very, very good thing. And it's something that every society should want to promote if they want a growing economy and a dynamic, political, healthy democracy.
Okay, and I know we've discussed innovation. What do we really mean by innovation for the layman, for the
I'm sorry?
layperson? Yeah.
But what does innovation mean?
Yeah.
Sure. There's a couple things. So first, there's a spectrum between what folks call very drastic innovations and incremental innovations. And basically, the idea is innovation is a new product, process, or technology, right, that is developed. Sometimes these processes are very minor, incremental innovation, right? So a great example is Apple comes out with a new version of the iPhone, right? That's an innovation, right? But it's an incremental innovation, right? It builds off an existing product and makes it better. Whereas on the other hand, you have drastic innovations, right? Radical general purpose technology changes that really change the world, fundamentally new products and new systems and new architectures like artificial intelligence, for example, right? Like, for example, you might also say when Apple invented the iPhone, right? That was a drastic innovation relative to what existed. So there's a spectrum between exactly how disruptive of the status quo an innovation is. But generally, innovation is a new product that is created. And again, it can range from very small incremental changes to very big disruptive, general purpose technologies. I would say it's a fair general working definition we could use.
Thank you. So there's a push to have structural remedies that can break up Google or other big platforms. And what do you think should be the most appropriate remedies?
Sure. So I think we do have some history we can learn from, at least in the United States, about structural remedies and whether they're a good or a bad thing. So one of the biggest breakups that we saw in the United States was, of course, of AT&T. And AT&T was very large. It's still very large, and it's important to note that it still is a telecommunications company. And it was sued for a very long time. And the basic concern was that AT&T was leveraging its power in the local network to benefit its long distance network, and that this was harming competition. And ultimately, what the Department of Justice decided to do was break it up in two ways, right? So first, it broke up all the local networks, right, into the baby bells. So the one national local network was broken up into a bunch of regional networks. And also, sort of, that's a horizontal separation, you might say, and it's the same product market, different geographic markets, and then you also had a vertical separation, right, where AT&T was forced to separate its local businesses from its long distance business, right? And ultimately, the effects of that breakup, I think, were bad for American competitiveness and American innovation. ITIF has written a lot about this. So on the one hand, and this is very Schumpeterian, a lot of the revenues and just the scale that AT&T enjoyed by having a large local network and also the long distance, but especially the local networks, helped to spur innovation and Bell Labs, which was their major research arm at the time. And ultimately, the breakup led to the collapse of Bell Labs because it didn't have the funding and the resources it needed to engaging in those long-run innovations. So that was, I think, a one consequence of how a breakup, a horizontal breakup, but also vertical breakup in general, was not helpful to innovation. Another thing I would point out is that ultimately, it's not even clear the breakup was necessary, right, to actually create the competition that the government thought was lacking. So there's some good evidence on this, but on the one hand, the wireless technology obviously was really what created competition in the telecommunication space. And it's not clear to me at all that the DOJ's breakup had anything to do with that, right? I think that competition still would have been forthcoming and ultimately corrected any market failures that the DOJ saw, irrespective of any breakup. That's another point. And then even on the static side, with respect to sort of lowering prices for consumers. there have been some studies that were subsequently done suggesting that actually prices in the United States weren't materially lower than prices in Europe, right? And Canada and other jurisdictions where there were no breakups, right? So that's again consistent with the idea that what was driving competition and consumer benefits was ultimately not the breakup. There were other factors, especially wireless. So I think the AT&T case gives us an example of how breakups don't necessarily work out the way the government thinks they will, and ultimately can have harmful effects on consumers and innovation. On the other hand, the Microsoft case, another large antitrust action brought by the government, is, I think, an example of where you did not have a breakup. A breakup was considered, but ultimately abandoned, but that those conduct remedies that were ultimately imposed were sufficient to ensure a healthy digital economy would follow, right? And I think the government even notes how successful the Microsoft remedy was in one of its in its complaint against Apple, right? So the idea here is that Microsoft was accused of leveraging its market power and its operating system to benefit its browser, but ultimately its operating system, because the browser was seen as a potential competitor, sort of Schumpeterian sense, the internet tidal wave it was called. And there was a real concern, and the district court ordered a breakup between Microsoft's operating system and its browser. But ultimately, they decided on conduct remedies, basically ensuring that Microsoft wasn't able to unfairly preference its browsers, using its power in the operating system. And again, what followed was, I think, a very healthy digital environment, and the internet flourished. Google, Meta, these companies were able to succeed. So the behavioral remedy did not get in the way of digital. It was sufficient, right, to ensure that internet competition, digital competition flourished. And ultimately, it wasn't damaging to Microsoft, right? Microsoft is still able to innovate in areas like cloud and things like that. So, and also now AI. So I think those two cases, AT&T and Microsoft, give us really great examples for seeing how, even if there are these antitrust concerns, how breakups can actually be really bad, and conduct remedies can actually be what you need to solve the antitrust concerns and also not get in the way of innovation, right? So I think those are two very helpful scenarios for sort of thinking about why breakups should be avoided in these monopolization cases. That's point number one. Now, if you want to discuss any specific cases, I'm happy to do so. But one of them that's obviously very important right now is Google, because a breakup is currently being considered of Google, which lost its case in the district court in Washington, D.C., basically saying that it had unfair payments to pre-install its search engine on various Android manufacturers and browsers. And as a result, the DOJ is considering breaking up Google in its recent remedies proposal. Among other things, it would like to force Google to divest Android, Chrome, or both as a way to solve these concerns. And one thing I would point out is this remedy even makes a lot less sense than a breakup remedy did under Microsoft or AT&T for that matter, because as I pointed out, under AT&T and Microsoft, there was this concern about leveraging, right? That Microsoft was using its operating system to benefit its browser, for example, and ultimately its operating system. And that AT&T, right, had this local network it was using to leverage and gain market power in its long distance network. That's not at all the allegation in the Google case. There's no allegation that Google is, for example, using its Android, any market power in Android or Chrome, right? Its market position in Chrome to benefit search, right? That's just not the case that the DOJ brought. So this idea of, we need a breakup because there's this leveraging and these two businesses can't stay together, that in theory could have made sense in Microsoft and AT&T at a high level because there was leveraging. But on Google, that's just not the case the DOJ brought, right? So even on these facts, I would say a breakup makes a lot less sense than it even would have in some of the earlier cases that we've seen.
Okay, thank you so much on the issue of remedy. So I think we have around just 10 minutes or less than 10 minutes. And one of the issues that I've been thinking about as a researcher on this topic is the issue of the power imbalances between African SMEs and the digital platforms that have become unavoidable trading partners because they provide the gateway for African SMEs to be able to reach the end users. And a lot of African SMEs have really benefited from this because they've been able to reach consumers at both local and international markets. So it has been said that when you look at the DMA, the critics argue that it seeks to protect competitors, and mainly those that are less efficient instead of protecting competition. But when you look at African SMEs, and especially from the market studies that are coming from the African continent, is that they do not have the same bargaining power as international chains or international businesses, because in some cases, they do not have the capital muscle to pay for paid search results on Google, or to pay for ranking and visibility on Booking.com. And even when we want to give them, grant them a conducive environment for innovation, it's not only about entering the market or also being able to expand within that specific market. So that's the problem we are having, a problem whereby we can create a playing field or fairness as the DMA tries to imply. And I'm just wondering, in your opinion, how you think in this scenario whereby we're trying to give opportunity not to the less efficient, but to those who do not have the bargaining power to participate in digital markets, how can we balance between enhancing competition in the digital markets ecosystem, as well as, I don't want to use the word fairness because it's really an elusive one, but in a way that we can also ensure that they are able to participate and compete on other parameters?
Sure. So I think your question actually raises an additional issue, and it's sort of different from the whole protecting competitors, protecting competition thing, but also whether or not antitrust law should be focused on exclusionary conduct. You know, we talk about that as harm to competitors, but also harm to consumers as well, and exploitation, right? In sort of the unilateral conduct sense. So this is conduct where a firm is not necessarily doing anything to exclude a competitor and gain market power, but it's exploiting power it already has against counterparties, right? And certainly in the United States, there really is no exploitation offense under the Sherman Act. You know, the Sherman Act is limited to contending, to fighting exclusionary conduct and not this sort of exploitative behavior. But the European Union, of course, does have authority under 102 to police sort of exploitative behavior, which is a firm, again, using market power it already has in a way that harms its counterparties. And, you know, I think a lot of the bargaining power concerns you're mentioning are sort of derivative of that. It's like, you know, they're very large, powerful firms. They have a lot of power, and they can use that power to get better terms, better prices, whatever it may be, against their counterparties, right? There's no exclusion necessarily going on there. It's just they have a lot of power. And what I would say is, in general, antitrust law should not be focused on exploitative conduct and of that kind, right? Now, that's not to say that if there isn't a monopsony, right, that if you have exclusionary conduct that builds monopsony power, for example, or that's totally different issue. But just the idea of a firm, whether it's a buyer or a seller, exploiting market power it already has, I don't think that should be a focus of the antitrust laws. And I think it gets back to the idea of innovation, right? And this idea that we don't want to penalize large firms from the fruits of success, right? Being successful and having power, right? Because that can chill the incentives for firms to create new product and compete vigorously, right? Because to get that power, to get those rewards, right? So there's a case in the United States called Trinco, where basically they say the monopolist, high prices, in some cases are an element of the free market system, right? Because when a firm wins, it gets those benefits. Now, to be sure, right, there could be some short-term harms, right, statically, right, to this type of behavior. There's no doubt about that. So you have this trade-off between long-run dynamic benefits, right, fostering innovation and allowing firms to get big, and then recoup those innovations through high prices, right? And on the other hand, the short-term harms to static competition that can happen from a large firm that can just price very highly. How do you weigh those two things? Well, the short answer is it's really hard to do that, right? It's really hard to weigh those short-run harms, higher prices, against the long-run dynamic benefits when you're thinking about exploitative conduct. And I think the policy choice that that I think makes the most sense is to focus on the innovation in the long run, right? It's really hard to weigh those things, if it's even possible at all, frankly. But the sound rule is to allow firms to compete and succeed, both because I think just sort of that's going to be just sort of how markets, I think, should work. You shouldn't penalize a firm just because it's successful, but at the same time, recognizing that high prices can be a driver of innovation, right? And part of that process of Schumpeterian creative destruction. So I think in general, a policy against exploitative offenses is a good one for antitrust enforcers.
Yeah, so that's what I was really thinking about, the intra-competition. So if we have a platform like Google providing the market, or Facebook marketplace providing the market, and the participants on that market provided by these big tech companies do not have an equal playing field. So the South African Competition Commission came up with some very particular remedies. And one of the remedies they indicated was that for Google to provide funding for SMEs in South Africa, or for the historically disadvantaged groups in South Africa, to enable them to be able to pay for the access. Or for Google, when it comes to the paid search results, where we have the paid search results, then organic search results, to ensure that when it comes to African platforms or businesses, they can appear in the organic search result on the first page. Those are some of the things, the remedies they recommended, so that we can ensure intra-competition now among businesses. Now we are going beyond just talking about Google and what, but those other participants on the Google platform. So as we summarize this, just the last question is about killer acquisitions. And if you think killer acquisitions, because most of the small startups will be in Africa, and we are seeing instances when these startups being bought through mergers or acquisitions, and most of them don't fall under the merger thresholds at the competition agencies. And what is your opinion about this? People argue that it kills innovation. So that's really...
Yeah, I think each acquisition obviously needs to be evaluated on its facts. I mean, there are certainly some cases where you can have harmful acquisitions that harm potential competition, right? That's certainly possible. But there are also many cases where acquisitions of potential competitors can be pro-competitive, right? And actually foster innovation, right? So many times for these companies that are smaller, they innovate, and they are engaged in a business model because they see that they can get acquisition as reward, right? So acquisition in a way supports and fosters their ability to dynamically compete. It's an exit opportunity, basically. And at the other side of the aisle, it's very, when it comes to showing any competitive harm, right? It can be very hard to show, for example, that without a transaction, such and such a company would have evolved to become this great competitor, let's say, for example. And of course, that's a big case that's going on right now in the United States, is whether or not Meta acted anti-competitively than Facebook by buying Instagram and WhatsApp, right? So, one of the things that the government's going to need to show is that, these companies would have developed and been as successful as they were, without all the big investments that Meta made in them, right? And had they just continued independently, they would have been able to succeed and be able to really compete with Meta. That can be hard to show, right? It's very hard to sort of make that but-for argument, the world in which the killer acquisition, so-called, didn't happen, that there still would have been all this great competition without the investments that the large firm was able to make in the product. So those are just really hard to prove in general, and I think that's why the FTC lost its case against Meta Within, for example, which was a potential competition case. But no, is there certainly a theory where you could find evidence to suggest that harmed competition? Yeah, absolutely. But it's not easy, and there are good reasons why it shouldn't be easy, because you don't want to chill those sorts of pro-competitive investments in small companies that can ultimately make them successful.
Okay, thank you so much, Joseph. I've taken a lot of your time, but
my pleasure.
Provided a lot of insights, and therefore we are going to conclude this discussion by you telling us in summary, so what should be Africa's best approach?
Sure. Well,
Yeah.
what I would suggest is sort of the big picture is that, and actually I did some numbers, actually before this, I took out some numbers. So if you look at IMF data, in 2001, Africa and China apparently had about the same average GDP per capita. They were actually very, very close, Africa generally, China. But of course, today, China's about 6.5 times higher in GDP per capita than Africa. And, you know, China has risen very quickly, in large part due to its ability to become a leading manufacturer and its success in dominating so many exports around the world, and also by being a high-tech economy, right? That's been the secret sauce that is used to rise very quickly. You know, and the 21st century is really going to be defined by this techno-economic rivalry between the United States and China. There's no doubt about that. And what I would say is sort of the interests of America and the West, I would include Europe in that. Our interests, I think, are to have Africa develop into a strong manufacturing hub, an innovative economy that can actually compete with China and a lot of the low-cost manufacturing that's going on over there. You know, whereas I think China's interests are to make sure it maintains dominance in global manufacturing. So I think from the perspective of the United States and the West, you know, we want to see Africa develop as a successful manufacturing hub and an innovative economy. But ultimately, I think Africa is going to have to make the choice as to sort of where it sees itself in that broader geopolitical rivalry between the United States and China. That I think is sort of the broader thing I'd leave you with, and certainly regulation that is focused on attacking successful U.S. firms, you know, is not going to bode well for a relationship, you know, that is focused on cooperation and again, healthy economic growth and innovation more broadly. So that's sort of my takeaway point, sort of the big picture geopolitics issue.
Okay, thank you so much, Joseph. And in conclusion, I would encourage each of us to visit the Information Technology and Innovation Foundation YouTube channel and also their website under the Center for Schumpeter Project on Competition Policy to have a deeper insights on this debate for and against digital market competition regulations, because when we bring together all these diverse discussions, then we'll be in a position to develop regulations or to also make use of the current competition law and policy regimes that we have to ensure that we have a strong digital market system. And also Africa, it has the potential, but Africa is lagging behind when it comes to digital markets. And we hope that the African Continental Free Trade Area competition protocol, as well as the protocol on digital trade, is going to stimulate innovation in digital markets. Thank you so much. And do not forget to subscribe and also to share this channel.
Thank you.